Hey guys, so today we're going to talk about civil liberties. Essentially, those are laid out in the Bill of Rights. We're going to hop on here and start off with the First Amendment. But first off, our Bill of Rights originally started out as 19 amendments that were proposed by James Madison. He didn't really want to do this, but it was pressured by a lot of the states. Of those 19 amendments, the House of Representatives would whittle that down to 17. And once it went through the Senate, it would come down to 12. Now, they would sit there until about 1791 when they would finally be voted on. And at that point, only 10 of them would pass. Again, I think I covered this in the last video, but the 11th of those 12 wouldn't actually become part of the Constitution until 1992. That one was passed. And all that did was make it so that Congress couldn't vote themselves a pay raise and receive that pay raise before the next election cycle goes through. So let's start off with the First Amendment here. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedoms of speech or of the press or the right of the people peacefully to assemble and to petition the government for redress of grievance. Now, this is something that we've seen time and time again be tested in the United States. One of the major ones actually took part in Texas in 1989. It was Texas v. Johnson, and that was whether or not burning a flag was protected under the First Amendment rights. Now, the courts ended up holding that burning the American flag is actually protected by free speech. And this case kind of affirms that the government can't prohibit expression simply because it's offensive or disagreeable. And it further expands the protections that we have and whether or not you agree with what it's being done or not. Again, the New York Times Co. v. the United States in 1791 was whether or not the government could prevent publications from publishing classified information. There was some papers that were known as the Pentagon Papers, and the Supreme Court ruled that the government could not exercise prior restraint on the publication of classified documents unless it could prove an immediate direct threat to national security. So this case reinforces the strong presumption against prior restraint and underscores the press's role in holding the government accountable. Those papers were leaked to them, but that went through like that. Again, the NAACP versus Alabama. This is all the way back in 1958 when the state of Alabama tried to get the membership rules from the NAACP. Now, what could they possibly want to do in Alabama in 1958 with those rules that would be a positive thing? But the NAACP was protected by the Supreme Court, stating that the state had no right to those documents proving associations, and that was under the freedom of association. Now, the Second Amendment we're all pretty aware of, and that is the right to bear arms. And it states, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, with that said, there have been several times over the years that that's been tested and that the Supreme Court has even sided with government to take a little bit of those freedoms away or to kind of restrict the kind of firearms that you can have. In the United States v. Miller, all the way back in 1934, the Supreme Court ruled that you do not have the right to have a sawed-off shotgun because it doesn't have a place in a well-regulated militia. Now, the case was pretty significant because it was one of the earliest interpretations of the Second Amendment, and the court suggested that the right to bear arms was connected to service in a militia, and thus it did not guarantee an unrestricted individual right to own any and all types of firearms. Now, interestingly enough, after making that ruling, we would later get into World War II, where we would use shotguns quite a bit in trench warfare. Now, the District of Columbia v. Heller took place in 2008. That's in Washington, D.C., where a police officer was able to get this all the way to the Supreme Court because in D.C., you weren't allowed to have your firearm outside of a safe or assembled. It had to be either disassembled or in a safe. But that kind of does away with the ability that you have to protect yourself with it. So once that goes to the Supreme Court, they actually overruled the D.C. law, allowing people to have firearms in their homes that were not in a safe or were not disassembled so that they would be readily available should you need to protect yourself. Now, Catano v. Massachusetts, this is in 2016. This actually expands your Second Amendment rights out a little bit. In this case, a woman was charged for using a taser on someone and charged because it wasn't a lawful firearm or lawful weapon. And in this case, the Supreme Court sides with the woman, and it expands the Second Amendment to any and all defensive weapons that a person may carry. So that would be mace, pepper spray, a taser, a firearm. Texas has recently expanded that even further, allowing people to carry any kind of weapon uh, outside of firearms, such as a knife, brass knuckles. Um, I mean, just lots of different things in the state of Texas that are now available that prior were not. That happened a few years ago. Now, the Third Amendment: no soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. So you don't have to allow soldiers to stay in your house unless you want to. Now, obviously, during wartime, sometimes that changes, even though it's clearly stated here. During the Civil War, this wasn't really enforced, as well as if we were at war with a different country. I don't see that this would be completely enforced the way that it is, but it has been tested over the years. England v. Carey in 1982 was over whether or not National Guard troops had the right to stay in housing that was given to prison guards. The court ends up siding with the prison guards. The National Guard was not allowed to stay in their housing. This was done because of a protest being done by the prison guards, and National Guard troops had stepped in to take care of the prison while they were in the middle of that. So they ruled against it. The National Guard troops had to move out of the housing for the prison guards. Now, it was tested again in Mitchell v. City of Henderson in 2015, and this was all the way out in Nevada. This took place because police invaded a home to use it for a tactical advantage against someone that they were trying to find in another house. Now, in this case, the Third Amendment didn't apply. The Supreme Court ruled against it. They said that police officers are not part of the military, therefore the Third Amendment does not apply to them. The Fourth Amendment is the right of the people to be secure in their persons, houses, and papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by the oath of affirmation, and particularly describing the place to be searched and the person or things to be seized. Now, there are several cases of this throughout the years that have gone to the Supreme Court, and this has expanded what the Fourth Amendment refers to. Over the years, it's expanded out to not being able to wiretap people's phones, to not be able to wiretap pay phones. I know you guys probably aren't that familiar with those anymore, but they can't even wiretap a payphone because it comes with the reasonable expectation of privacy. They can't look into your home with infrared or anything like that without a warrant because, again, you have a reasonable expectation of privacy. And this is expanded out as technology is expanded. One of the places that this applies is with your cell phones. So a police officer can't just walk into Verizon or whichever cell phone carrier that you use and demand your phone records. They have to have a warrant to get that. No one can actually do that. In fact, there was a time that I used to work at one, and every once in a while we would have that happen, or we would even have a girlfriend or a spouse or a boyfriend or whatever come in and try and get phone records because they thought someone was cheating. If you're not on the bill, they can't give you those records. Those are private. Which takes us to the Fifth Amendment. No person shall be held to answer for capital or otherwise infamous crimes unless on a presentment or indictment of a grand jury, except in cases arising in the land of naval forces or in a militia when actual service in time of war or public danger. Nor shall any person be subject for the same offense twice, so that's double jeopardy. Nor shall they be compelled in any criminal case to be witnessed against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So this is saying that they can't just come take your stuff, and they can't force you to testify against yourself. Now, as well, there's double jeopardy in there, and that's saying that they just can't try you for the same crime twice. Now, that's not saying that you get caught committing a crime, you were tried, you found guilty, you get out, or you're found innocent and you get out and you do that same crime again. That's a different crime. Okay, I've had that question a few times. Committing the same crime two different times doesn't count as the same thing. All right. Now, one of the times that this was brought up is relatively important. That's Miranda v. Arizona in 1966. And this was over a case where Ernest Miranda was arrested for kidnapping and rape. And then during his police interrogation, he confessed to his crimes, but he was never, they never read him his rights, which led to the Supreme Court case, Miranda v. Arizona, where they said that, well, if your rights aren't being read to you, then you may not know them. So some of that ended up getting thrown out. Now, while he was still convicted of some of the crimes, he wasn't convicted of everything. But from that point forward, we had what's called the Miranda rights, which most of you heard that the police will read to you. They generally have them on TV, things like that. They don't actually have to read them to you right when they arrest you. They just need to be read to you before you're interrogated, although in most cases they're going to read them to you as you're being arrested. Now, this is going to take us all the way to the Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have assistance of counsel for his defense. So that's one of the ones that has actually been tested in the Supreme Court. There was a case, Gideon v. Wainwright in 1963, and that was whether the Sixth Amendment right to counsel applies to defendant in state courts who can't afford an attorney. So prior to this case, if you were in a state committing a state crime, not necessarily a felony, you didn't always have a right to counsel. With this case, that changed. Now everyone has the right to counsel, regardless of the kind of crime that you committed. If you can't afford an attorney, one will be appointed to you, right? The Seventh Amendment, in suits at common law, where the value in controversy shall exceed $20, the right of a trial by jury shall be preserved, and no fact tried by a jury shall be otherwise reexamined in any court of the United States than according to the rules of common law. So, someone owes you $20, technically you could sue them over it and get a jury trial. Don't necessarily recommend that, but that's the way that this one's written out. That one might need to be updated at this point in time. You get $20 as a juror just for showing up, so that would end up costing a lot more than the amount in the suit. The Eighth Amendment, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. Now, on this one, there are several cases over the year that have made it to the Supreme Court over the death penalty. And in those cases, it's been overturned. It's been made illegal. It's been reinstated. The death penalty has been back and forth. The state of Texas alone is responsible for us knowing things like the fact that you can't put mentally handicapped people to death. These cases come and go. I'm sure there'll be more of them in the future. The last major one to make it to the Supreme Court was Ramos versus Louisiana, and that was all the way back in 2020. Now, as far as excessive bail goes, that one is something that they kind of set depending on the crime. But you don't always have to give bail. So that one's always kind of confused me as to why they do that. If a crime is bad enough that you don't want someone to get out, don't allow them bail, just hold them without bail. If you're going to grant them bail, according to the Eighth Amendment, it has to be reasonable. And I think that probably has more to do with how much money a person makes. If you're a multimillionaire, $300,000 or $1 million even isn't that big of a deal for a bail for you to pay. But if you make $30,000 a year, I mean, that's a stretch just to ask for $30,000. Reasonable would be something that a person is able to pay if they actually needed to. It takes the Ninth Amendment. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Meaning that the Constitution can't be used to take rights away from people. Okay. Now, this one's also been tested throughout the years, but we're going to go all the way to the 10th Amendment. This is one that is going to join up with federalism, and that is the power is not delegated to the United States by the Constitution, nor prohibited by it to the states, or reserved to the states respectively or to the people. And this one has been tested as well several times throughout the years. A lot of the times from Texas, this has been something that's come up, and essentially it's saying that there are certain things that the federal government cannot force on the states. That if the law is not a federal law, then the states can't do anything about it. Now there are several places uh, where this is covered by the articles of the Constitution. The U.S. Congress has a lot of things that they can do laid out in there. They have the Commerce Clause, which allows them to control commerce between all states and other countries and Native American tribes, actually. They have used that several times in the past. They also have what's called the Necessary and Proper Clause. In the Necessary and Proper Clause, they have the ability to do whatever they deem necessary and proper to do their job. Now, that's pretty broad, and it gets used that way quite often. So that's going to bring us to the end of our Bill of Rights and your civil liberties, and I'll see you in the next video.